We entrust judges with administering equal justice under the law. It is critical to our democracy that the American people have confidence that judges cannot be bought or influenced, and that they are serving the public interest, not their own personal interest. Over the course of several decades, Congress and the judicial branch have created a system of ethics laws and standards for federal judges that lay out the clear rules of the road. These rules promote transparency and disclosure. They place guardrails on conflicts of interest, provide mechanisms for investigation and enforcement, and ensure accountability for misconduct. They strengthen faith in the fairness of the courts and the judges who serve on them. We are here today because the Supreme Court of the United States of America does not consider itself bound by these rules. I invited the Chief Justice to join this conversation. Last week, he sent me a letter declining to testify at today's hearing, and he said, quote, "Separation of powers concerns and the importance of preserving the judicial independence." The reality is that sitting justices have testified at 92 congressional hearings since 1960. And I even offered the Chief Justice the opportunity to designate someone else on the court to testify. But I'm more troubled by the suggestion that testifying to this committee would somehow infringe on the separation of powers or threaten judicial independence. In fact, answering legitimate questions from the people's elected representatives is one of the checks and balances that helps preserve the separation of powers. In his letter last week, the Chief Justice also sent what he called a statement of ethics, principles, and practices. It was a document that was attached to his letter. It is an extraordinary document, not in a good way. It makes clear that while the justices are fine with consulting with certain authorities on how to address ethical issues, they do not feel bound by those same authorities. Much of the document explains why justices think they should not be treated the same as other federal judges when it comes to ethics. And it stresses that recusal decisions are made by individual justices alone, with no review of their discretion. The Chief Justice's letter and statement of principles are a defense of the status quo, but they are oblivious to the obvious.